hit record. Let's see, live transcription. Okay, how's everyone tonight?
Super great.
Doing well.
I'm sorry?
Doing okay.
Say that again.
Well, super great.
Excellent. Okay, any questions or comments on anything that we've done so far?
On the final, the grade said that it doesn't unlock until next week, but I think you were saying it unlocks this week.
Yeah, it should unlock on the, it should unlock tomorrow, I think. Because the, but I'll check that after the office hour. So you're saying,
If you go to it, it says available after March 2nd.
oh. Okay. Yeah, I'll have to check that because the, according to the syllabus, the final exam is due on Monday, February 28th.
And if you check on the grades where the final exam is listed, it says available March
Right.
2nd through March 7th.
Okay. Oh. Okay, that's, sorry about that. That's obviously a big difference. Well, thank you for bringing that to my attention. Okay. See, I'm trying to, can anybody, for some reason, I can't see my screen. Can you all see it? There we go. Let's see. Share. Okay. Huh. Now, for some reason, the screen is, I see it, but it's really tiny in the middle and I can't, let's see. Okay. For some reason. Okay, share. I think. For some reason, when I hit share, I see Delwyn. I'm sharing Delwyn, but not the slides.
So I don't know, maybe if you minimize this window, because I can see the slides behind that.
Wait a minute, say that again?
Can you minimize that window? Because I can see your slides behind that.
Okay, maybe that's, so minimize. How's that?
There we go.
Okay, excellent. All right, so we're going to consider both transnational organized crime, which is chapter 5 of the text, and also then international evidence gathering. So looking at transnational organized crime, we're going to consider it both from the perspective of the US and international organizations. And we've seen that the United Nations Secretariat has identified 18 categories of transnational and mostly organized criminality. And, as we know, globalization has enabled criminal organizations to network and cooperate, merge their expertise, and broaden the scope of their activities. And also, globalization has also enabled transnational organized crime to network and cooperate with non-organized criminal groups like terrorist groups. So there's a lot of different criminal groups out there that try to collaborate for various projects and various activities. So in the US, the most important law is the racketeering statute, which is one of the main mechanisms by which prosecutors go after organized crime. And undoubtedly, the most important recent case has been the FIFA indictment, the indictment against the soccer organization, which was brought on May 27, 2015. There's a 47 count indictment charging 14 defendants with RICO, wire fraud, money laundering conspiracies, alleging a 24-year scheme through corruption of FIFA. And basically, it alleged that the different confederations of the soccer organizations, along with some national member associations, were conspiring with sports marketing companies, and that they all constituted an enterprise of entities associated for purposes of regulating and promoting soccer, and that they got their revenue by basically receiving bribes from through allowing access to media and marketing rights associated with these world soccer events and tournaments. And basically, the soccer officials, the ones from the various countries that are officers in either the international or the regional soccer confederations, were charged with soliciting and receiving over 150 million in bribes and kickbacks. So the defendants are soccer officials acting in a fiduciary capacity within FIFA, the sports, media, and marketing company executives, businessmen, bankers, and other intermediaries who help launder the payments. The whole case started as a tax investigation, and then one of the criminal agents, the IRS agents, realized that, hey, this was more than tax. This was really about organized crime and all kinds of bribery with respect to the World Cup. And before the indictment, this FIFA, which is based in Switzerland, they knew they had problems, and they commissioned a 450-page report by a former US attorney for the Southern District of New York into the World Cup bidding process. And he, said, his 450-page report basically said, yeah, there's a ton of problems and you guys better do something about it quickly. But they suppressed the report. And so later on came this huge indictment. Now, a lot of people said that the US shouldn't be prosecuting this case because most of these acts happened outside the US. And who does the US think it is anyway to be, basically the policeman of the world? I appeared on Russian TV on this issue, back in 2015 or 16. And I pointed out that, look, there were a lot of mail and wires that went through the US. The US financial system was used, and both to pay the bribes and also to invest some of the bribes. One of the major defendants had his office in Miami. Another one was in New York. A lot of the marketing, the sports apparel companies were in New York. And there were all kinds of involvement of US persons, including US participation in the bid for the 2022 games, which of course has gone to Qatar. So in a lot of these prosecutions are still going on. Some of the defendants have not been extradited, but most of them have. And the US has even started paying some of the money that's been forfeited to the victims. There have been a number of big cases brought by foreign governments, including the European Union, which, that's an international organization, of course, against tobacco companies like RJR Nabisco and other persons for allegedly smuggling cigarettes into the EU and in other countries without paying VAT, the value-added tax. And the RJR Nabisco case alleges that Colombian and Russian drug traffickers smuggled both cigarettes and narcotics into Europe, and used black market money brokers, cigarette importers, and wholesalers for large shipments of RJR cigarettes into Europe. But RJR moved to dismiss because it said, look, most of this stuff, most of the alleged activity occurred outside the US. District Court agreed, but the Second Circuit overturned it and concluded that there was a lot of things that happened in the US. Because the circuit courts were split, it went up to the US Supreme Court, and the majority opinion said that the court was going to throw out the case, that there's still a presumption of against extraterritoriality, and that it looked like most of the injury occurred abroad. There was a very strong dissent by Justice Ginsburg, who noted that, look, all the defendants are US corporations. They're headquartered in the US. The racketeering activity alleged is directed and managed from the US, and therefore this case clearly should be in the US. But no such luck. So a lot of the contemporary US prosecution of organized crime figures rely on US conspiracy law. Now, there's mentioned in the book Presidential Decision Directive 42 in 1995. Now, this was during the Bill Clinton administration, when transnational organized crime was a big priority. And during the 50th anniversary of the United Nations, President Clinton wanted to do something big. So a couple of months before the National Security Council organized a group of about 5 people, in which I participated as one of the 5. And we came up with that One of the potentials is that president could announce an executive order using sanctions to block the assets of leaders, cohorts, and front companies of identified Colombian narcotics traffickers in the US and US banks overseas. Now, the way this was supposed to work was that foreign governments were supposed to do the same thing. So just like today, when the US announced sanctions against Russia, and you had the EU, the 27 countries in the EU, and about 6 other countries that all announced sanctions against Russia. The US and President Clinton hoped the same thing would happen with respect to sanctions against narcotics traffickers, but the other countries really did not follow through. So the executive order, I would say it was only of medium success or even less. The US has a number of transnational organized crime working groups that are done under the mutual legal assistance treaties, which we'll talk about very soon in this hour, namely the ones with Italy, Switzerland, and Mexico. So basically the way it works is that twice a year, the transnational organized crime working groups will meet for a few days. They'll discuss, they'll prioritize cases and how to work them. And these working groups have been quite successful. So many countries have specialized ethnic organized crime groups to go after, for instance, the Chechens, the Chinese, the Albanians, Nigerians, the Russians, Colombian, Sicilians, the Albanians. And the reason they have these ethnic organized crime groups is that these groups normally speak not only in their own languages, but even in their own dialects. And so a lot of times when you get a wire to surveil their conversations, you've got to have people that speak the dialects. So I used to teach at Fordham Law School in New York, and the guy that I co-taught with, a guy named Abraham Abramovsky, he was big on Russian organized crime, and he knew a lot of the Russian organized crime police that worked in Odessa, Odessa being a part of Brooklyn. So from time to time, there are meetings of the organized, the law enforcement that work these organized crime groups. So for instance, the US and Canada will meet and they'll, share how-to on these different organized crime groups. The US internationally is famous for pioneering the use of anti-money laundering and forfeiture laws as a way to take down transnational organized crime. The US has been doing that. We did it against in the 20s. And that's been a big contribution of the US to international treaties. The US also has deported large numbers of members of gangs to Central America and the Caribbean. But a lot of times this strategy, I think, has backfired because those small countries can't cope with large members of transnational organized crime, and they end up just repeating their crimes. And a lot of times they target the US, from those other countries. They just use other people to go into the US and steal cars or steal, whatever. and sell them abroad. Well, a big recent case, of course, was against El Chapo, who was the head of the Sinaloa cartel. He was convicted of 26 drug-related violations after a 12-week trial, and the jury was anonymous and partly sequestered. And the difficulty for the defense was that El Chapo was detained in solitary confinement. There were massive amounts of discovery that were difficult to review in a timely manner, and the government's reliance on cooperating witnesses was difficult for the defense. So the prosecution presented testimony from 56 witnesses, 14 of which worked with El Chapo. And of course, El Chapo was famous for escaping in 2014 when his safe house was raided, when he was in bed with his mistress, and they were able to slip out. There was a trap door underneath the bathtub, and it was to the sewer system. He had his motorcycle, and so he it opened to a tunnel where he escaped. But eventually, and of course, he also escaped from prison. His wife helped him there, again with there was a tunnel from the prison that went miles, and again he was able to escape through, in this case, the shower in the jail. His wife also, by the way, has been arrested and convicted. She's a dual national US Mexican, was a former beauty pageant queen. But the problem is that every time they take down the leader of a cartel, or even a cartel itself, new cartels emerge. So President Trump issued an executive order with respect to transnational organized crime, but he tended to mainly go after the Salvadoran gangs that were dealing with immigration. And these are really more like gangs as opposed to transnational organized crime. They don't have that much money or that much power. MS-13, I mean, we have a bunch of them in DC and the suburbs, but they're more immigration gangs. They haven't been successful at amassing a lot of money and power. Also, the Trump administration went after the cartel Jalisco Nueva Generación and was pretty significant. Was pretty successful in taking down many of the Jalisco Nueva Generación. There's a good book by Evan Ellis that was written in 2018. He's a friend of mine, with respect to going after organized crime in Latin America and the Caribbean. He noted that the way that the Trump administration came out against a lot of Latin Americans, and the cancellation of his scheduled participation in the Summit of the Americas had not made it, had not really enabled the US to establish effective partnerships with respect to going after transnational organized crime. So the US has had things like Plan Colombia, Plan Merida in Mexico, the Caribbean Basin Security Initiative, the Central America Regional Security Initiative, and the Alliance for Prosperity. These have all been US programs, basically giving financial and technical assistance for things like helicopters and armaments to go after transnational organized crime, especially the drug cartels. And on December 15 of last year, the Biden administration issued an executive order establishing a U.S. Council on Transnational Organized Crime. This is more of a whole of government approach. It tries to use both intelligence and traditional law enforcement, like, prosecution against transnational organized crime. Let's see how it works. So internationally, we have the UN Palermo Convention against transnational organized crime, and that is in the book. It's very broad in terms of the requirement of signatory countries to criminalize all kinds of activities related to transnational organized crime, including money laundering, corruption. It makes legal persons liable. It also states that countries have to use sanctions, they have to use confiscation, and there's all kinds of mutual assistance and extradition required. There's also 3 protocols of the Palermo Convention, one on trafficking in persons, another on smuggling of migrants, and another on illicit manufacturing of or trafficking in firearms. The US is a member of all protocols except one. Guess which one the US is not a member of? Anyone want to guess? How about
I'm gonna
illicit
guess firearms.
Yep, the firearms protocol. And I'm organizing a webinar on that for the American Bar on firearms trafficking, talking about the UN Convention against trafficking in firearms, the OAS Convention against trafficking in firearms, and this protocol through the Palermo Convention. It'll also be focusing on the lawsuit brought by the Ministry of Foreign Relations in Mexico against US gun manufacturers, charging that they are specifically making and marketing their high-powered weapons to the Mexican cartels. So the EU is also a signatory to the Palermo Convention, and the EU has a framework decision to combat organized crime. Also, the Council of Europe has been active, and the OAS has a special group on transnational organized crime. There's also some informal international groups. So the G7 has made a number of resolutions on transnational organized crime. And also the Davos World Economic Forum has a group on organized crime, because the multinational enterprises realize that, hey, they have trouble even competing sometimes with organized crime. And so they've, formed a group that's called the Global Agenda Council on Illicit Trade. Well, no, there's actually an organized crime council that builds on the work of this Global Agenda Council on Illicit Trade to try to, crack down on transnational organized crime. So different countries have, different approaches to organized crime, including, Italy and Mexico. In the EU, Europol is very active because, the EU has to contend with Italian organized crime. There's a lot of organized crime in the Central and Eastern Europe, in places like Bulgaria, Romania, Hungary is big, and even in Albania, which is, although it's not an EU member, because it's right next to Italy, Albania is very active in the EU. So let me stop here and entertain any comments or questions that you all have. Okay, no comments or questions on transnational organized crime. Okay, well then, let me then turn to international evidence gathering. So, international evidence gathering. Okay, so here we're going to look at unilateral means of gathering evidence, as well as then looking at letters rogatory and using mutual legal assistance treaties as a way to gather international evidence. And here the US has a lot of ways to unilaterally gather evidence. They issue subpoenas against, they issue subpoenas to US nationals or residents who are abroad. They also compel the production of documents located abroad whenever they have jurisdiction over the alleged wrongdoer. They can compel the production of documents from that are located abroad from a third party that is not the target of the investigation, as long as they can show that they have somehow they have jurisdiction over the person who's not a target. So, for instance, a bank might have a branch in the US, or a corporation might have a branch in the US. They also compel, they issue subpoenas on foreign witnesses that are passing through the US. So a lot of times, somebody from the Cayman or Bahamas or Belize, when they're going somewhere abroad, the people in Cayman and Bahamas will pass through Miami. Where do the people in Belize pass through? Usually Houston or Dallas or Narlands. And so, and a lot of times, US law enforcement will have the passenger airline list. They'll look at the list and they'll see, here's someone who's passing through Houston on their way to Spain. And it's just the person that we want to subpoena. Or even sometimes, of course, arrest. They also will compel production by serving a subpoena ducis tecum on an officer or custodian over whom the US has personal jurisdiction. They also will compel consents to disclose third-party records to overcome bank secrecy. So they'll say, okay, you're a defendant before me, and the judge will say, I want you to disclose your bank records in Switzerland, or let's say Austria, and the person will say, well, I can't, there's bank secrecy there. And the court will say, I don't care about bank secrecy. I'm going to hold you in contempt unless you you turn over your records, because I know that even though there's bank secrecy, you can circumvent it by consenting. So I was involved in a case in re Marsner, which was in Arizona. I think it was in Tucson. And I was hired as a consultant. And I said, well, if I were you, I would whisper in the ears of the Austrian government and tell them that the US is trying to override your sovereignty by, making this defendant circumvent your bank confidentiality laws. And so sure enough, the Austrian government said, we are seizing these documents and we're not going to turn them over because you're right, the US is trying to override our sovereignty. So another way is to compel targets of US criminal investigations and defendants not to seek action abroad. So there's a law that we'll mention in a minute that requires targets in a US case, if they're going to try to bring an action abroad, to block prosecutors' evidence, to obtain evidence, they've got to give notice to the prosecutor. So for instance, I was involved in some Swiss cases where Swiss banks, as a part of their offshore voluntary disclosure settlement with the US, were required to disclose the names of all of their employees and officers who had helped US taxpayers to conspire to evade US taxes. So I filed a declaration in Swiss court saying, Your Honor, if you make these Swiss banks turn over to the US Department of Justice the names of these bank officials, some of them are going to get prosecuted. And so in those cases, the Swiss courts blocked the banks from squealing on their employees and officers because it's also a matter of Swiss fundamental law under their constitution and their bank confidentiality laws to violate Swiss bank confidentiality. In some cases, courts will require asset repatriation in order to pay fines, taxes, or forfeiture. And there's also a tax statute which even will put someone in jail for not agreeing to repatriate their assets when they're shown to owe taxes and or penalties. So compelled consents. There's a Supreme Court case that says that compelling consents do not violate the right against self-incrimination. There have been some cases that are mentioned in the text on 380, the Verdugo-Urquidez case, where the US tried to use in court evidence from an alleged narcotics trafficker that it seized in Mexico without a warrant, without getting a US warrant and without getting a Mexican warrant. And when the defendant tried to use the exclusionary rule, said, I have a right under the Fourth Amendment again to be free against illegal searches and seizures, it went up to the Supreme Court and it was held that, the Fourth Amendment only applies to US citizens. And since the defendant is a Mexican citizen and not a US citizen, he can't use the Fourth Amendment. Now, I thought that decision was lame because, in an era of globalization where people are traveling every day, especially between places like Texas and Mexico, to start making decisions on people's citizenship when, if your legal system is to have integrity and fairness, you shouldn't start distinguishing between citizens and non-citizens in terms of the fairness of your procedures and the rights of defendants to be able to rely on constitutional provisions. There have been some cases I discussed on 383, the Balsas case, where defendants raise the right against self-incrimination with respect to a potential foreign prosecution. And the US Supreme Court has said, oh no, you can raise the right of self-incrimination in a US case. I mean, if you're afraid of a US prosecution, but you can't use it in a foreign prosecution. I thought the better reasoning, the better decision was the dissent. And maybe that's because the dissent cited one of my articles, and again saying that in a globalized world, we should treat alike the right against self-incrimination, whether the fear is a US or a foreign prosecution. There are a lot of cases where defendants try to throw out illegal interrogations abroad. And there's something called the silver platter doctrine, where the Supreme Court, where courts say, unless the method of interrogation is such that it shocks the conscience of the court, or where US law enforcement has participated substantially in the interrogation, they're going to allow in those interrogations. And so what often happens is US law enforcement will be in the next room and they'll whisper in the ear of the foreign interrogators, what they should do. And in most cases, especially as the Supreme Court has become increasingly conservative, the court will allow in those interrogations. Increasingly, electronic evidence is an issue, as you can imagine, in transnational criminal investigations. There was a big case involving Microsoft, where the Microsoft was ordered to turn over evidence that it had involving a drug case, but the evidence was actually stored in Ireland. And so Microsoft said, you can't just issue this warrant. The US should use the Mutual Legal Assistance Treaty with Ireland if it wants that information, because our clients' privacy rights, and especially the European Data Privacy Act, shields our customers' data, which is not kept in the US, it's kept in Ireland. The district court agreed with Microsoft, but the Court of Appeals overruled. And it went up to the US Supreme Court. All kinds of groups filed amici curiae briefs, some by US law enforcement agencies that said, this is very important. US law enforcement has to have access to electronic data stored abroad. Ireland and the EU filed amicus disagreeing, saying you can't infringe on their sovereignty and especially the fundamental privacy rights. High-tech and communication firms filed briefs and said, it's important to have data privacy. Privacy-focused civil society NGOs also said the US shouldn't infringe on cross-border privacy protections. But before the Supreme Court could decide the case, Congress actually enacted the Cloud Act, which clarified that yes, US electronic providers must comply with an order from the US government, even when their data is held abroad, and that the other part of the law gives foreign law enforcement access to US held data, but only if those countries have a data privacy or a Cloud Act agreement. And then there are various criteria that try to restrict the US to only enter into Cloud Act agreements with those countries who show that they have appropriate procedures to safeguard privacy, even though, as we know, the US has much lower standards than, for instance, the EU does. But in any event, so far, the US only has 2 of these Cloud Act agreements. In the 4 years that the act has been in existence, the US has only concluded agreements with the UK and Australia. So still the electronic evidence, it's tricky for US and foreign law enforcement, especially because criminals can plan their affairs so they can have non-US providers hold their data. And they can also even choose a non-US based service provider who doesn't have US presence, so the US can't subpoena that person. And yeah, some countries also have what are called data trusts. So a non-US data provider can use a trust so that his data is not stored by the service provider. Instead, it's automatically transferred to a trustee who then stores the data on independent servers. So then when the US tries to compel the non-US service provider to turn over the data, that company says, well, I don't have it. The trustee has it. And so I don't have access to it. So there's all kinds of complexities with respect to efforts to gain access to electronic data that's held abroad. So then another important means, international means to cooperate in terms of evidence gathering is letters rogatory. So there's a statute, 28 USC 1782. So there's the provisions of it are on page 388. So that allows one court to assist a court in a foreign jurisdiction in terms of gathering oral testimony or gathering documents. It's based on comity. It's important to know that it's discretionary. It used to be that US courts would see if the evidence gathering that was requested was possible in that foreign country before they agreed to give that type of assistance to foreign countries. But there's a Supreme Court case in 2004 that said we don't have to do this dual discovery requirement anymore. And here's the 18 USC 3506 as I mentioned, is that any US national or any US resident who applies to a foreign court or authority opposing a US government request for evidence must serve that pleading on the US Attorney General. So wherever possible, law enforcement tries to use a mutual legal assistance treaty because unlike letters rogatory, mutual legal assistance treaty is mandatory. There's a legal obligation, and there's also a competent authority. So the competent authority for the US is the Office of International Affairs in the Criminal Division of the Department of Justice. And that, there are, probably 40 lawyers there, and they're assigned to different countries. So for instance, the attorney in the Office of International Affairs in the Department of Justice assigned to Mexico talks to his counterpart in Mexico maybe 5, 10, 15 times a day. I mean, maybe they talk by phone, they talk by email, they probably had beers together a number of times. They know each other's, know each other's families. And so there's a strong bond usually between the competent authorities. They get to know each other's laws. Now, importantly, the beginning of the MLATs have a provision that says this treaty, so you see it on page 399 in the MLAT between the US and Russia. It says in Article 1.4, it says the treaty is intended solely for the cooperation and legal assistance between the parties. The provisions of this treaty shall not give rise to a right on the part of any person to obtain evidence or have evidence excluded, etc. So what that means is that if you're a defendant, if you're a criminal defendant, you're shut out of the MLAT, even though you might be locked up and therefore you have trouble, getting evidence to, have a fair trial. So in the late 80s, I got the American Bar Association to pass a resolution, which was hotly controverted by some of the prosecutors in the ABA, a resolution that said these provisions are unfair. And then I got the Senate Foreign Relations Committee to hold a second hearing on a group of MLATs that they were considering. And I testified that members of the committee, please make a reservation, understanding or declaration to these MLATs because they're very unfair. And even though I convinced Jesse Helms, the chair of the Senate Foreign Relations Committee, to hold this hearing just on this point, unfortunately, the committee did not agree with my my testimony, and the U.S. approved those MLATs, and all of the U.S. MLATs now, since the late 80s, have this provision. Notwithstanding that, I've been able to convince one judge, a U.S. district judge in Alaska, who was hearing a case involving a Dutch cruise liner that dumped oil into Alaska. I was able to convince the judge that that provision was unconstitutional. And the judge basically said, I don't care what the MLAT says. In my court, there's going to be equality of arms between the defendant and the prosecution. So prosecution, if you don't allow these defendants to take depositions in Holland about this case, I'm going to throw out the case. I'm dismissing the case. And so the prosecutors said, okay, we will allow the defendants to use the MLATs. And then before long, they got a plea to a misdemeanor, and that was the end of the case. Some MLATs have dual criminality provisions, so they say unless the crime is a crime in both countries. This was inserted by the Bahamas and the Cayman Islands and Panama with respect to, because they didn't want MLATs to apply to tax cases. So there's a dual criminality provisions. So importantly, there's a lot of regional conventions on mutual assistance. So again, remember I mentioned Tuesday, the Inter-American Convention on Mutual Assistance. Also, I mean, because that could be helpful in one of your exam questions. There's also all of the multilateral conventions that we mentioned. The Palermo Convention on Transnational Organized Crime, the UN Convention Against Corruption, the UN Convention on the Suppression of Terrorist Financing. All of these conventions have mutual legal assistance provisions. So if you're a prosecutor, you can rely not only on bilateral MLATs, but also on these multilateral conventions with MLAT provisions. There's a denial of MLAT request for abuse of process that happened. The Canadians denied MLAT requests for the case of Mr. Schneider. And international human rights provisions are used to challenge MLAT requests. There's also a whole series of mini MLATs. So those are mutual, those are mentioned on page 409 of the text. So that means, for instance, there are a lot of mutual memorandum of understanding between the Securities Exchange Commission and its counterparts. Similarly, between the Commodity Futures Trading Commission and its counterparts. Similarly, between the Antitrust Division of the Department of Justice, and also there are tax information exchange agreements. So there was a case recently at the end of the Trump administration involving the case of the Beatles. These were the two individuals who were raised in Britain. They became a part of an ISIS terrorist cell. They beheaded some Americans. The U.S. U.S. indicted them. They asked the British for evidence. And at first the Brits said, well, looks like you could give these people the death penalty. That's a violation of the European Convention on Human Rights. So we can't, give you evidence unless you promise that if we give you evidence and you prosecute these people and they're convicted, they won't get the death penalty. Eventually, the US agreed, and the British gave evidence, and eventually the British also surrendered these people, and the US are prosecuting them now in Alexandria, Virginia, US court in Northern District of Virginia. So let me stop here and take any comments or questions that you might have. Let me see. There's wow. There's a few chat
Actually, that was
messages.
just a side conversation that we're having. It was going to whether the Constitution is rules that the government are supposed to abide by, or does it apply to individuals in certain instances? Side conversation.
Oh, okay. No, I understand. Okay, yeah. So any other thoughts or questions? I will look right away into the question about the when the exam is going to be available and due, because I think that's obviously very important. So can you guys think of anything else? No? Well, if not, let me say it's been a real honor and a pleasure to have been able to share these 6 weeks with you. And I wish you success in the rest of the course and your program at Texas A&M, and also your careers. And I would be delighted if you were to keep in touch with me, and if I can help you in any way in your careers, don't hesitate to reach out, whether it's like a question or about a some matter that you have, or anything that you're interested in. And so with that, I thank you very much for your attention. So all the best. Cheers.
Thank you very much. And it's been an honor with some of the cases that you've been involved in. It's very impressive. Thank you for your time.
Oh, no, thank you very much.